Hello, welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I am the Third Circuit representative for the Young Lawyers Division Board of Governors. Today we have the pleasure of hearing from Joe Bodiford. Joe is board certified in criminal trial law as well as certified in criminal trial advocacy by the National Board of Trial Advocacy. Today we're going to be speaking about trial and post-trial ethics in criminal cases. Joe, welcome.
Good morning. Thanks for having me.
Absolutely. First of all, are there any special ethical concerns in trying a criminal case?
Yes, there are a lot. The main one is competence. Now, being a trial lawyer myself and teaching trial advocacy at Stetson University College of Law and actually finishing an LLM in advocacy, I'm a big proponent of being able to effectively advocate in the courtroom. And I believe that the effective assistance of counsel not only applies to diligently investigating the case and informing the client, but I think it also deals with one's ability to stand up in a courtroom and make an effective jury selection in a criminal case, to connect and to communicate with a jury in opening effectively and persuasively, to conduct good crosses, to conduct effective closing arguments. Anytime you're talking to a jury and you're advocating your client's story, you're making it your story, and you're making it the jury's story, that requires special competence. So when somebody's looking at taking a case, I believe that they've got to look at that charge and think, one day I'm going to be in front of 6 or maybe 12 people, depending on the crime. Can I competently do that? That to me is the biggest issue in a criminal case.
What about ethical concerns with jurors in a criminal case?
Well, as Mater, the tow truck, said in Cars, I think the best way is to not to. Our bar rule says that you cannot approach and communicate with a juror unless there is an issue of whether or not there's been some jury monkey business. And I think if you look at what I call the 600 rules, 3.600, and those that talk about post-trial motions, if you get in a situation where you think that the jury has somehow separated when they weren't supposed to during deliberations, when there has been maybe, as they say, decided by lot, where in other words they just flipped a coin to see what that can be done, but get a motion from the judge, or motion the judge and get an order from the court to be able to speak to them. Don't approach a juror, especially young lawyers who want to know how they did, they want to know how that cross was. Stay away from the jurors. If they want to talk to you, if they approach you and they offer some comments, I believe that the bar would say that's okay. But don't approach jurors. Stay away from them.
Are there any special concerns with post-trial issues in criminal matters?
Yes. One of the most important things that I would tell anybody who's taken a criminal case, or really any case, is make sure you look at Florida Rule of Judicial Administration. I said judicial administration, it's criminal. Rule of Judicial Administration 2.505. That says that a lawyer is still the lawyer on a case, absent a motion to withdraw or absent an order allowing you to withdraw, until 30 days after the case has become final. Well, in a criminal case, that would be 30 days after the rendition of a sentence. So that means that during those 30 days, even if your client's pled and they've been sentenced, or they went to trial and they've been sentenced, and you walk out of the courtroom and you say, hey, I'm done, I can go close the file. No. 30 days, you are still the attorney of record, and you have ethical obligations. And one of those obligations is to go talk to the client about an appeal. Go talk to the client about new trial motions. Go talk to the client about motions to mitigate sentence. Those are things that are the duty of the attorney. So many times I've seen notices of appeal not get filed because the attorney said, well, the client didn't tell me he wanted to appeal. And I look at him and I say, he just got 20 years after the jury trial. How could you not go and talk to this individual? So that is the main ethical post-trial issue for an attorney. You're still on the books. You still have ethical obligations. Fulfill them.
Do you recommend doing that in writing as well? Have the verbal conversation and then follow it up in writing?
Anytime you can do anything in writing and document your file, that is important. It's not necessary, really, but it is certainly the safest way to do it.
So with that, that's a perfect segue into when do you actually stop being a defendant's attorney?
Well, again, the rule of judicial administration would say without any order or anything else, 30 days after the judgment and sentence has become final. Many attorneys will make it a practice once the case is over, if it's a plea, and they know that the client is not going to be appealing or challenging the sentence in any sort of way, they will go ahead at the end and say, Judge, I also ask the court to allow me to withdraw. Sometimes they do it orally in court right after the plea is done, and the judge will grant it. Sometimes it requires an actual separate motion. But don't assume that just because the judge has gavelled the case closed that it's over with.
All right, Joe, thank you so much. And that concludes this video. Thank you for watching.